And I have around 30 minutes, right?
Yes, sir. So we'll start now. Uh, Good morning, everyone. On behalf of Dr. Narottam Sahu, advisor at GUJCOST, and our whole team, I welcome our speakers and participants for this day 2 of summer camp on IPR designed for college and university students to engage, educate, and empower them in their career and future. The objective of the program is to create a strong IP culture among the students because universities and institutes are considered to be the most important foundation for growth of any country. So on the first day of our summer camp, we saw a wonderful session on IPR basics and importance in the academia and how we can proceed for smart way of IP creations. We have seen a job opportunities in the IP industries, importance of patents in bio, pharma, and life sciences, computer related inventions and their registration procedure, etc. So let's start with the day 2. Today we will learn more on the IP commercializations, technology transfer, etc. So today we have our first speaker, Dr. Anand Bhandar sir. We welcome you, sir. So yeah, he has done his MSc, PhD, MBA in marketing, and PG diploma in financial management. So he has a total 25 years of experience as a techno administrative researchers and in the teaching field. So he also got several awards, medals, and currently he working as a joint director business development at the GSBTM DST Government of Gujarat and founding director at a Savli Technology and Business Incubator DST Government of Gujarat. So we'll proceed with the first session with Mr. Dr. Anand Bhandar sir. Yes, sir. We can start.
Okay, thank you so much for your generous introduction. Um, Very good morning to all of you, and I hope you are able to see my slides. So, the topic assigned to me today is IP commercialization of biotech products. I understand you also have students, undergraduate students, as well as postgraduate students, as well as teachers. So, I'll sort of shuttle between Hindi, English, and Gujarati, whatever it is, English and Gujarati or whatever. Yeah, so that we are able to connect with students better. Um, first thing first, thank you, Dr. Sahu is a very dear friend now for many years now. GUJCOST is another home. It was the first place where I landed coming to Gandhinagar. So, GUJCOST, thank you so much for having me here. Also, uh, put on records my thanks to Mission Director GSPM, current and past, my team, a lot of mentors uh, who have had a role in shaping me up, and yeah, some of the slides that I would want to show are some case studies done by some senior organizations. So it is for educational purpose and there is no infringement of any IP rights into it. So I propose that let the today's discussion thread be like this. We have to talk of IP commercialization of biotech products. So there are two components: IP commercialization and biotech products. So what is IP and its commercialization? IP तो थोड़ा बहुत आपने कल जान ही लिया, लेकिन उसका commercialization ये क्या चक्कर है? Okay, and why is commercialization of IP important? आपने देखा भी होगा recently there is this discussion about compulsory licensing for COVID vaccines वगैरह वगैरह. So it is important to understand as to what happens when there is compulsory licensing or why. And we will want to take this through case studies of IP commercialization of certain biotech products so that we understand अच्छा ये impact होता है, ये समझने के लिए case studies समझना जरूरी है. I'll also talk about if you are to endeavor on this path, where all can you benefit from, or what are the benefits that are offered by the organizations that I come from, GSBTM, STI, or TSIR, TOCIC, and so on and so forth. So let me start with this first slide. Please, Jikisha and Dr. Shredi, let me know whenever there is loss of connectivity or whatever. All I can see is I can see only my slides, and I
Yes, sir.
believe
Will
that that my voice is going, but the camera is working, etc., etc. Correct.
yeah.
So only one slide to talk of to give the context. Okay, we know that way back 1745 to 1845, that century, we saw iron come up, water power, mechanization, textile, commerce. So this wave came in. This is called as the first wave of technology. The second wave of technology is steam power, railroad, steel, cotton. So that was the second wave of technology or second wave of innovation. Then came electricity, chemicals, combustion, and so on. Then came petrochemicals, electronics. Okay, somewhere around the year 1990 to 2020 is called as the fifth wave of innovation, where we saw digital networks, softwares, information technology, biotechnology booming. And of course, the newer one will be clean technology, biomimicry, lots of other things. Okay, but can you see this red arrow? Okay, here somewhere one important thing happened, and that is we started thinking, how do we sustain, how do we promote this innovations, how do we make it faster? You get to see जो इधर 100 साल हुआ, जो इधर 100 साल लगे, वो उसके बाद ये 50 सालों में हुआ, और ये तो एकदम 25-30 साल में ही हुआ. और ये आप देखो कि this is a 30-year gap hardly. Okay, even less than that, and you can see the amount of, I mean, there was a vertical climb. So what makes, how you get to see in lesser time greater innovation, and that is possible because of commercialization. Okay, now what do I mean by that? Let me take you through something. So see, an innovator, and here are a large number of, it could be industrial designs, it could be copyrights, it could be plant varieties. GR is genetic resources, GI is geographical indications, PK is traditional knowledge. Okay, patents, trade secrets, and so on and so forth. Okay, know-hows, and so on and so forth. So there are lots of them. Okay, but it is important that the that the uh, that the innovator benefits out of it. Now here is an example, okay, of different types of, maybe designs, maybe patents, maybe trademarks, maybe copyrights. Okay, it is important that the innovator feels encouraged, right? This is an example of glowfish. Okay, so, or immunovac, aspirin, okay, recombinant cotton, you all of us know of BT cotton, water purifiers. Okay, see, it is important that the interest of inventor, of the innovator is kindled. Okay, उसको तो कुछ encouragement feel होना चाहिए, right? वो कब होगा? जब उसको मिलता, उसको लगता है कि मुझको इसमें से पैसा मिलेगा. और वो पैसा कब हो सकता है? Only when there is a negative right which does not allow others to copy it, and he is alone allowed to commercialize it, right? Only when that IP generates revenue, when that IP results into commerce, and it is transcontinental, पूरा वर्ल्ड में से कहीं से भी मिल सकता है, तो ऐसी सूरत में ही हो सकता है. I'll take you through certain examples. Okay, now starting with copyright. Okay, it's the simplest of the forms. Okay, copyright क्या होता है? Copyright ये होता है, मान लीजिए मैंने अपने वाइफ के लिए एक पोएट्री लिखा, राइट? तो मेरा लिखा हुआ पोएट्री है, ऑल आई नीड टू डू इज जस्ट सी, लिख के मैं उसको सर्कल कर दूंगा, मेरा कॉपीराइट ये जो है ही इसमें. सो दिस इज द साइन ऑफ कॉपीराइट. ओके, आई कैन रजिस्टर इट, बट आई नीड नॉट रजिस्टर इट, बट इट कैन स्टिल बी माइन. बायोटेक्नोलॉजी में ऐसा कुछ आता है क्या? हाँ, ओरिजिनल रिसर्च रिपोर्ट्स आते हैं, आर्टिकल्स आते हैं. आप कुछ ड्रग के लिए आप कुछ लिख रहे हो, तो उसमें कॉपीराइट वगैरह आते हैं. But other than this, I want to take you through a particular controversy. Okay, actually, spotlight, okay, in the field of biotech industry, in terms of copyright, is about modification of genes of plant. फिर वो genes plants के हो एनिमल्स के हो, माइक्रो ऑर्गेनिजम्स के हो, टू आइडेंटिफाई कॉजेज ऑफ डिसीजेस, टू मेक एसेज फॉर टेस्टिंग ऑफ वेरियस डिसीजेस, मैन्युफैक्चर ऑफ वैक्सीन, ये सब के मैटर में कुछ कॉपीराइट आता है या आ सकता है। तो इसके बारे में थोड़ा सा कंट्रोवर्सी चल रहा है। देखो, डायमंड वर्सेस चक्रवर्ती से शुरू हुआ, लेकिन इशू ये है कि मान लीजिए कि मैं कोई डीएनए सीक्वेंस, ओके, मैं बनाता हूं मतलब मैं उसको ऑथर करता हूं, ओके, तो will I will I stand the benefit of copyright? Okay, because can it be analogous to literary work? Okay, तो इधर जो sweat of bro doctrine काम आता है, is it merely a compilation? तो ये सारे aspects इसमें आते हैं। ओके, यूएस में काफी चर्चा चला, ओके, कि किसको लिटरेरी गिनना चाहिए, ओरिजिनल है कि नहीं है। जो जो फॉर एग्जांपल मेरा जेनेटिक सीक्वेंस, ओके, इसकी मालिकी किसकी है? Who owns it? Me, myself, my parents, or the entire society, or so on and so forth. Okay, so a lot of these aspects, but our focus is not into getting into this. Our focus is how do we commercialize it? Commercialization of this component is going to be important. Okay, and of course, entire controversy I am marking in these 2 points out here, that originality, ओके, देखो डीएनए सीक्वेंस किसका है, बात सही है कि वो मेरा है, बट द रिसर्चर्स हैव स्पेंट कंसिडरेबल टाइम एंड एफर्ट टू डिसर्न द सीक्वेंस ऑफ अ जीन, ओके, सो बिकॉज ऑफ दिस हार्ड वर्क शुड देयर बी कॉपीराइट और नॉट, ओके, तो ये सारा कंट्रोवर्सी आया है एंड इस पर से बहुत सारा कमर्शलाइजेशन वगैरह के मैटर्स हैं। अब मैं सीधा एक केस स्टडी पे लेके जाता हूँ जहां पर this is J. Mitra versus Span Diagnostics. Okay, and the judgment was passed in 2008. Okay, so what was the story? J. Mitra developed a highly HCV. Now this enables disease to be diagnosed within 10 to 15 days after the virus has attacked the body. Okay, it applied for patent. In the meantime, giving बाकी के मैं डिटेल्स में नहीं जाता हूँ कि कैसे एक स्पेसिफिक सेट ऑफ एंटीजेंस यूज्ड, ओके, ये सारा किया था। अब इसमें देखो पैटेंट भी आता है, इसमें कॉपीराइट भी आता है, सारा कुछ आता है। Span Diagnostics copied HCV tried-out product. Okay, Span Diagnostics was in Surat. Okay, अभी तो उसको जापानीज कंपनी ने टेक ओवर कर लिया। Okay, Span had initially opposed the grant of patent. Okay, and patent office ने उनके ऑब्जेक्शंस को रिजेक्ट कर दिया था। इसके बाद जो है जे मित्रा ने फाइल किया उनके सामने, जब ग्रांट हो गया तो जे मित्रा फाइल द केस अगेंस्ट स्पैन डायग्नोस्टिक सीकिंग इंजंक्शन कि स्पैन ने एक सिग्नल एचसीवी जो बनाया है वो एक कॉपीड डिवाइस है एंड इट शुड नॉट बी अलाउड, ओके, बिकॉज द मेथोडोलॉजी इज नथिंग बट प्रोटीन। उनका कहना है कि भाई दिस इज कॉमनली नोन और इसके लिए इट शुड बी अलाउड। हाउएवर एट द एंड, कंसीडरिंग lot of other documents and the work that has been done, okay, Honorable Justice Sanjay Kaul, इन्होंने ये decision दिया that there are sufficient documents which shows that research has been conducted by J. Mitra, okay, and the international preliminary examination report issued by PCT office does not have a bearing on the validity of the patent. Okay, that was one of the contention. Okay, and the defendant showed no research or development towards it in जो प्रोडक्ट है उसमें जो डिफेंडेंट है उसने कुछ किया हुआ नहीं है। तो ऐसा कर करके, लेकिन इससे क्या हुआ? It stopped Span Diagnostics from coming up with the product and it gave sole rights of commercialization to J. Mitra. Okay, now this led to enormous business and जो एक्चुअल इनोवेटर था जिसने इन्वेंशन किया उसको बिजनेस करने को मिला, उसको कमाने को मिला। तो इस तरीके से जो है इन्वेंशन को सपोर्ट मिलता है। ओके, अब ये एक इंपॉर्टेंट केस जो हुआ onto this, I will directly focus on to, because see, our title is commercialization. I believe you know by now what are the features of, I mean, patent की जब बात करते हैं तो patentability क्या होता है, कैसे यूनिकनेस क्या होना चाहिए उसका, मार्केटेबिलिटी वगैरह। पैटेंट दोनों को लेकर के जो कमर्शियलाइजेशन की बात आई, वैसे ही एक और जो एक बिगेस्ट सक्सेस स्टोरी है दार्जिलिंग टी का, प्राइमरली आईपी कमर्शियलाइजेशन की वजह से जो हुआ। लेट मी टेक यू थ्रू दिस। You will get to see a detailed case study on WIPO web elaborate study। इसको कंपाइल करके कुछ एक स्लाइड्स में आपको स्टोरी बताता हूँ। देखो क्या होता है कि दार्जिलिंग 1835 से स्टोरी शुरू होता है। अंग्रेजों ने जो है काम शुरू किया, अंग्रेज चाय के शौकीन थे और उन्होंने उधर बनाना शुरू कर दिया। उतना ही नहीं, फिर हाँ जी
Sir, are you changing the
Please tell
slide?
me.
We are on DNA as a compilation slide.
Can you hear me?
Yes, sir. Are you changing the slides?
I think some connection issue. So. Yes, sir.
Oh, so
I think some network issue,
so
sir.
let me stop my video. That will give better bandwidth.
Sure.
Okay.
Right, and let me again present. Let me first go there, make it full screen. And then can you see the slide?
Yeah, Darjeeling tea. It's about Darjeeling tea success story. Yes.
Yes. Okay. So this is a story of how commercialization of IP led to a huge success. Okay. So I was telling you that the Britishers, they were fond of tea, and they actually took a lot of business to Europe, and you got to see that a lot बाहर भी चाय बिकने लगी जो वो क्लेम करते थे कि ये दार्जिलिंग टी है। दार्जिलिंग टी क्या, जो दार्जिलिंग में बने उस चाय को दार्जिलिंग टी बोलना चाहिए ना। तो ये नहीं, अब दार्जिलिंग के नाम से आप अपनी चाय बेचो, इज दैट अलाउड, इज दैट एथिकल, इज दैट गुड इनफ? तो इसके लिए अब यहाँ पर जीआई, ज्योग्राफिकल इंडिकेशंस का स्टोरी आएगा, यहाँ पे ट्रेडमार्क का स्टोरी आएगा और कैसे इसको कमर्शियलाइज किया। ओके, अब दिस दार्जिलिंग टी इंडस्ट्री इन इंडिया, ये आजादी के बाद मैं जो बात कर रहा हूँ ये 2003 के आगे की बात कर रहा हूँ। ओके, 2003 में हम लोग जागे, तब तक में ऑलरेडी 52,000 people were employed in this Darjeeling tea industry. There were other 15,000 that are employed only during the season, उसका जो peak season होता है, इसमें lot of them are women. Okay, and ये जो गार्डन वर्कर्स है, और आप तो जानते हो कि असम के टी गार्डन्स में तो अब माफिया भी बहुत सारा। Okay, and that we ensure benefits to the plantation worker. We should ensure that they get better prices. We should ensure that there is better economical health, sustainable education, health systems, better quality of life. ये सब हम लोग चाह रहे थे, उनके लिए स्कूल, कॉलेजेस, बिल्डिंग्स बने ये। लेकिन हालत क्या था, इन 1997 जो है दार्जिलिंग लोगो ऑलरेडी नेदरलैंड्स, लक्समबर्ग, बेल्जियम इन्होंने लेने, दे हैड स्टार्टेड विद दिस। ओके, फिर थॉमसन ने भी एक कॉन्फ्लिक्टिंग मार्क वगैरह ले लिया था। यूके ने 1998 में दार्जिलिंग वर्क पे सर्टिफिकेशन मार्क दे दिया था। यूएस ने 2002 में दिया, तब जाके 2003 रशिया ने भी दिया, तब जाके इंडिया में 2003 में, एंड वी स्टार्टेड अ आईपी प्रोटेक्शन रेजिम। ओके, फिर क्या किया हमने, सबसे पहले जीआई मार्क फाइल किया, फिर उसके आगे हमको 2004 जुलाई में मिल गया, और फिर जाके वी स्टार्टेड गोइंग बैक टू जापान, गए ऑस्ट्रेलिया, गए जर्मनी, गए ओके, सब जाते गए और फिर हम लोग उस पे राइट्स लेने लगे। इससे क्या फर्क पड़ा? सी, फ्रांस में एक ये बदमाश था दुसोंग नाम का, कैन यू सी दिस मार्क? ओके, दार्जिलिंग चाय विद दिस टी पॉट उसने ले लिया था। जब हमने उसको कंटेस्ट किया, हमने मतलब इंडिया ने जब कंटेस्ट किया, तब जाके ट्रिब्यूनल ने उसको एक्सेप्ट किया एंड इवेंचुअली इन कोर्स ऑफ टाइम उसको पेनल्टी भी दिया, सारा चार्जेस भी मिला। सिमिलरली यूएस में भी हुआ। ओके, देयर वेर हम लोग का जो एपेलेट बोर्ड, जो जिसको बाद में टी बोर्ड मतलब हम लोग बोलते हैं, टी बोर्ड ने उसको बहुत ज्यादा परस्यू किया। यूएस में प्रोटेक्शन लिया, दूसरे कंट्रीज में प्रोटेक्शन लिया, ताइवान में प्रोटेक्शन लिया इन 2009। ऐसे सब करने के बाद क्या हुआ, नाउ दार्जिलिंग टी के नाम से आप चाय बेच सकते हो कहीं पर भी, लेकिन दार्जिलिंग टी के नाम से जो चाय बिके वो सिर्फ और सिर्फ दार्जिलिंग में बनी हुई चाय ही होनी चाहिए। तो बायोडाइवर्सिटी का भी देखो इसमें इम्प्लीकेशंस है, ज्योग्राफिकल इंडिकेशंस के इम्प्लीकेशंस है, ट्रेडमार्क के इम्प्लीकेशंस है। ये जो नीचे तुम देख रहे हो, या जो सबसे पहले वो लेडी वाला जो दिखाया था, तो that is the trademark of Darjeeling tea. Okay, so commercial angle is as important as GI protection and other legal angles. तो ये सबसे फिर दूसरे टी बोर्ड टी फेस्टिवल्स करने लगा अलग अलग कंट्रीज में। आप देखोगे इंटरनेशनली पेरिस के एयरपोर्ट पे आपको दार्जिलिंग टी का एडवर्टाइजमेंट मिलता है, आपको हिथ्रो लंदन के उसमें आपको उसका मिलता है, आपको ऑस्ट्रेलिया में आपको एडवर्टाइजमेंट्स देखने को मिलते हैं। दीज आर द टाइप ऑफ एडवर्टाइजमेंट्स, बॉर्न इन इंडिया एंड सेलिब्रेटेड वर्ल्ड ओवर, ऐसे सब टाइटल से। ओके, कॉग्नैट, शैंपेन और दार्जिलिंग, ऐसे सारे जब किए। अच्छा, सिर्फ इतना जरूरी नहीं था, इसके साथ देयर हैज टू बी अ प्योरिटी और इंटीग्रिटी, उसका भी तो थप्पा जरूरी था। ओके, तो इन्होंने क्या किया, इन्होंने ट्रेड चेन मैनेजमेंट सिस्टम, सर्वेलेंस, ओके, इस टाइप से पूरा कंप्यूटराइज। बागान में क्या पिक हो रहा है वो इंटरनेट कनेक्टिविटी से आप, आई मीन सीसीटीवी कैमरास वगैरह से आप कैलकाटा में बैठे बैठे उसको मॉनिटर कर सकते थे, और आप देख सकते थे भाई कितना चाय का पत्ती जो है आज प्लक हुआ, कितना प्रोसेस हुआ और कितना आगे चला। ऐसे सब करते करते जब गए, डेली ग्रीन लीफ प्लकिंग रिकॉर्ड्स, डेली मैन पावर यूज्ड, बाकी सारे रिकॉर्ड्स। ओके, जब ये सब होते गया तो इवेंचुअली दैट मेड वैलिडेशन और सर्टिफिकेशन। सो IPR प्लस क्वालिटी चेक्स प्लस ऑल ऑफ दिस, तो ये सब की वजह से हुआ क्या, ये मैं फाइनल इम्पैक्ट, I'm missing out all of these supply chain mechanisms, and we could give guarantee saying that everything that leaves Indian shores, and अगर हम उसको दार्जिलिंग टी बोल रहे हैं तो it is 100% guaranteed दार्जिलिंग टी। ओके, तो इससे क्या इम्पैक्ट हुआ, दार्जिलिंग टी सर्वाइव्ड। ओके, दार्जिलिंग टी, this is 2020 figures just before COVID. Okay, we were anywhere close to I think ये 20,000 होना चाहिए, ये फिगर थोड़ा सा गड़बड़ है, 5,000 to 20,000 करोड़। ओके, 10,000 करोड़ तो 2009 में ही था, तो 20,000 करोड़ इंडस्ट्री 2020 में हो गया था, from 5,000 to 20,000 करोड़। ओके, and Darjeeling tea was able to survive the lows. Okay, जो सारे हमारे ऑब्जेक्टिव हमने सबसे पहले बोला कि जो प्लांटेशन वर्कर्स को बेनिफिट होना चाहिए, उनके लिए स्कूल कॉलेजेस, उनके लिए सारा कुछ, वो पूरा हम लोग कर पाए। एंड इतना ही नहीं, बड़ा से बड़ा कंपनी हिंदुस्तान यूनिलीवर हो कि दूसरे सब है, दे हैड टू चेंज। पहले लिप्टन ग्रीन लेबल के नाम से बनता था, नाउ दे हैड टू लिप्टन दार्जिलिंग टी, ऐसा उनको करके बेचना पड़ा। ओके, तो ये सबसे जो बेनिफिट्स हुए, ये कमर्शियलाइजेशन के जो बेनिफिट्स हुए, इससे कॉमर्स में कितना फर्क पड़ा। देखो, सिर्फ पैटेंट फाइल करना, सिर्फ ट्रेडमार्क फाइल करना या कॉपीराइट फाइल करना इज नॉट इम्पॉर्टेंट, उसको कमर्शियलाइज भी करना चाहिए. So my focus in today's talk is on to the need for commercialization. Okay, I have only 2 minutes left. I will quickly take you through what all benefit can you draw from the organizations that I come from if you endeavor onto this path. Okay, so we have a cluster innovation center from DSIR MST GOI, wherein we support innovators to the tune of 90% of project cost or up to 2 lakhs, or 90% of project cost up to 20 lakhs in phase 1, in phase 2 up to 50 lakhs, 50% of project cost or 50 lakhs. So if you are an innovator, please reach out to me, we'll be more than happy to support you. That is one. This is the second one. Okay, biotechnology policy supports innovators in large number of ways, but I want to draw your attention to the last component, patent protection, IPR protection. If you are a startup, we support up to 14 lakhs. If you are units, up to 25 lakhs. R&D institutes, contract research, ये सब में भी हम लोग बहुत ज़्यादा सपोर्ट करते हैं. IP क्लिनिक फ्री ऑफ कॉस्ट चलाते हैं. ओके, कहाँ चलाते हैं? तो ये सावली टेक्नोलॉजी एंड बिजनेस इंक्यूबेटर है. इधर हम लोग आइडिया डूडल फ्री इंक्यूबेशन स्पेस, इफ यू आर एन इनोवेटर, सरकार की तरफ से है. इक्विटी बेस्ड सीड फंडिंग भी अवेलेबल है. इस टाइप का इंक्यूबेटर है, इस टाइप के फैसिलिटीज है. आप हमारे वेबसाइट पर आकर के देखोगे ना, तो मैं आई विल कम टू दैट. सारे इंस्ट्रूमेंटेशन है, यू कैन कम एंड यूज. ओके, दिस आर द इंस्ट्रूमेंट फैसिलिटी. stbi.gujarat.gov.in. ओके, और ये देखो, अक्रॉस द वैल्यू चेन, एक आइडिया फॉर इट टू बिकम अ प्रोडक्ट, पूरा वैल्यू चेन है. और इस वैल्यू चेन, अक्रॉस द वैल्यू चेन देयर इज लॉट ऑफ सपोर्ट मैकेनिज्म्स. फंडिंग सपोर्ट 1 लाख से लेके 25 करोड़ तक अलग अलग फंड्स है. इसमें से ये जो STI फंड 1 एंड 2 है, ये गुजकोस्ट खुद ही करता है. POCIC फेज 1 एंड 2 जो है, ये DSIR के वती हम लोग उसको संभालते हैं और फिर दिल्ली भेजते हैं. ये BT सीड फंड भी बायरैक के वती हम लोग करते हैं. ये बाकी सारा जो है वो GSBTM के फंडिंग में से आता है. You have any questions, you can reach out to us. I'm available on GDVDBTM, okay, at gujarat.gov.in, or simple wala gujaratbiotech@gmail.com. I'll be more than happy to be of any help. I have sort of exceeded a few minutes, but I'm sure it was worth for you, as in अगर आपको कुछ भी चाहिए, please reach out to us and I'll be more than happy to be of help.
Thank you so much, sir. It was a very wonderful session. So we have one question from Bhavna Singh. So she wants to understand that can we copyright, patent or complementary DNA sequenced what we have developed in lab? If no, how we can
So as of now, this controversy is going on. Okay, not only that, जैसे हम लोग अपने इमेजिनेशन से कविता लिखते हैं. मान लीजिए कि मुझको मालूम है कि ये कंपनी जो है ये सीक्वेंस के बेसिस पे कुछ कर रहा है. तो मान लीजिए मैंने कुछ भी काम नहीं किया और मैं अपने घर में बैठे बैठे एक सीक्वेंस, इमेजिनरी सीक्वेंस जो है वो ऑथर करता हूँ. So is it protected or not? We are still into this controversy. It is yet to be out. Okay, as of now we cannot do it. Okay, but on
I think, sir, your voice is not clear.
answer question. Can you hear me now?
Yes, sir. Yes.
You know?
Sir, your voice is breaking, sir.
सर डिस्कनेक्ट होके दोबारा से कनेक्ट होइएगा सर।
It's okay, sir. So, yeah, yes. I think some network issue. So if you have any question, please drop in the chat box. So we'll just forward it to Anand Bhandar sir. Thank you so much, sir, for the wonderful session. Just for the time limit, we'll move to the next session with Mr. Jitendu Roy, sir, because our second speaker was Mr. Akash Bhavsar, sir, but he had some health issue. So we thank Dr. Jitendu Roy, sir, to accept to talk on the topic in the very short notice. Yes, sir. Sir, you are muted.
Good morning. I am audible now?
Yes, sir. Very much clear.
Okay, great. Before I put my slides together, I just must say that since Akash was supposed to take this presentation, and I'm just stepping in because he had a certain serious health problem which he has to, for which he cannot come down, and he wanted me to be talking on this subject, and I thank Gujarat Science and Technology Council to give this opportunity to SkyQuest. I am associated with SkyQuest and had been in this space for technology transfer, primarily in the biopharma. And though the slide presentation is from the SkyQuest, but many of my examples or whatever since the audience is students, I will try to make it simple and help them understand how the licensing process happens and what is this licensing. Because since morning, I think what I saw in the list of speakers, they are adequately competent on discussing what IPR is and what are the importance of IPR, and they probably might have been told about how it is to be protected and what best can be done. What are the litigation issues and how companies have to manage through that. And as we know, the whole story of IPR is to protect an innovation, which why we need to protect that innovation is because there is a good potential to make revenues out of that, and that is the whole purpose of getting an IPR. And that is most of the companies who take risk need this protection. So as we say, now you have been aware of what IPR is. Now I will step into the different space. Once you have the IPR, what to do with it and how do you value it? Valuation is a very complicated topic. I may not touch on this 30 minutes. It's too short. But what exactly goes on after you have an IP, and you seem to have believe that this is an IP which can fetch revenues and can create a social impact. Social impact in the sense that it might be a new drug which might cure a particular disease condition, or it might be a kind of electronics which might make info data communication faster, or there might be so many aspects of, or it might be an energy storage device which takes transportation to a different level. But my talk will primarily have a bias towards pharmaceutical, because that is the most complicated of the technology transfers you will come across. It's not that the other sectors are not so complicated. Yes, IT is. So is space technology, so is defense technology, and there are so many issues around each of the technology transfer, and it will take maybe a week to understand each of the subjects in granular details. But since the audience is students, it is more important to have a global overview and to help you understand that what exactly might be happening in the other side. Many a times people or researchers come across with a technology and they start engaging with a company, and they believe the bigger the company, more the chances of making it a success. But that is not true. The bigger the company, more complicated the deal becomes. And I will explain in one of the slides I just put it in, you must also understand what goes inside the company and what is their decision points to pick up a technology. And that is where the actual money for an IP is. I'm just putting... I can slide share. Window. Share. Yeah. The slides are visible now?
Yeah.
Okay. Now, now I will be talking about licensing. Licensing is the process by which the IP rights, in basic, I am not getting into the complicated definitions and the granular legal definitions. Just try to understand the philosophy behind licensing. Somebody has developed intellectual property, and that property has a potential to generate revenues and create a social impact. That rights to use that intellectual property is given to somebody to commercialize, because a researcher who has developed the technology may not be in a position to commercialize it because it has a lot of other complications before it reaches the market. So this is the process is called licensing, and this is where actually this is the first major step where you see IP getting into the process of making money. Now, coming to what are the specific difficulties in licensing as the topic demanded, challenges and opportunities. So I will take up the difficulties. Difficulties in licensing out an early stage technology. Now, I probably might have understood by now what is the early stage, late stage and mid stage technologies, just so that for the audience, if it has not happened, an early stage technology is one which is at the lab, that is in an institute. Now, what happens in context of pharmaceutical? There are multiple steps of research before it hits the market. Unlike in IT, the technology just needs a process development and testing in the field, and it can go into the market. That is normally IT or electronics. The product development cycle is very small. But in case of pharmaceuticals, the product development cycle is extremely elongated and long, and it might last, post-licensing, it might last 6 years to 14 years. And we all know that it is because either it has to go to a basic stages of preclinical toxicology, then you have to go through the 3 phases of clinical trial, and then you have to go through the regulatory process where you have to defend your data and get the approvals. So now, this all depends on what kind of disease, what kind of technology, and what kind of disease you're trying to address. So the duration of those, this whole process is pretty elongated. And as you know, for a licensee who would be taking up this technology, he's taking a longer risk of maybe 12 years, 13 years before he will see any money coming into his account. And for 13 years, they have to keep investing. So in company which will try to invest, normally the companies, they always look at an opportunity which suits them, and they can see a revenue in space of 2, 3, 4 years. So what actually happens is companies then try to look at opportunities which is at the late stage. Then if companies are trying to look at opportunities at a late stage, because try to remember, you cannot short circuit the process. in pharmaceutical. Preclinical hona hai to hona hai. Phase 1, phase 2, phase 3 hona hai to hona hai. So you cannot short circuit those steps. Then what you can do what a company would look at, and what a researcher who has developed a molecule, for example, would look at, and because how these two can meet finally, because both have dramatically different challenges to handle. The licensor would look at quickly to get it into the licensing process and put it into trial phases, which is a huge sum of money. A trial might go up to $300-400 million, and I have been I have been working with a French MNC in the space of vaccines, and I saw a single trial of HIV vaccine costed $700 million, though it was funded internally and some from multilateral agencies, and this trial was done in Thailand and it failed. So 700 to the money of tune of $700 million, which in Indian rupees would not less than be 5,000 crore rupees, just went down the drain. So it was a huge risk a company takes while they move into the different trials process. And when it fails, companies go bankrupt. So it is a huge risk a company takes. But a researcher believes that his molecule is the best. It is going to change everything, and probably whole that particular disease will be cured, and this is the panacea for everything. So but there are two pillars at two different ends, and somewhere down the line, both has to come together at a meeting point. It might be a different process, different molecules have taken different routes, and finally, a successful molecule, you can say, at the end of the day. And again, successful commercialization doesn't mean a regulatory approval. Many people believe that regulatory approval mil gaya to kaam ho gaya. Nahi. There is an even bigger challenge when you have a new molecule to put it across to the user. And in pharmaceutical case, these users are typically the doctors who are the buyer of this idea, and then he prescribes it to the patients. Now, I can share a very interesting example for Pfizer. You all know this company, Pfizer, because of their vaccine today. And they are one of the largest company in pharmaceutical space, and had been successful in marketing new molecules over years. They're one of the largest molecule brand. There was Lipitor, which is anti-cholesterol, which went up to the revenue of $20 billion. So that means a single drug was getting in $20 billion. So that kind of company, they picked up a molecule called Exubra, got all the regulatory approvals, all data fine, everything fine, and they spent a huge sum of money. And then they finally launched the product. This particular product was inhaled insulin. Like you take inhalers, you might have seen inhalers like salbutamol, etc. jo lete hai asthma patient. They use the same process for this insulin. Now, it is an innovative product. Jinko insulin lena hota hai, they know what kind of pain it is to get that injection every now and then and keep monitoring the glucose. It is a difficult life for them. So this was a very interesting technology. The trials were perfect. Trials showed that this can be a replacement for the injectable insulins. So obviously, the regulatory and US FDA approved this product, but with one clause in that. And that simple clause was that since this is not the natural route for giving insulin, that we don't give insulin through the nose, we give it injectable. Since this is not a natural route for giving insulin, doctors, more additional data needs to be generated to prove the safety. And this had to be printed on every insert and pack which Pfizer had to sell. And also, while Pfizer had to educate the doctors, they also had to mention this to the doctors. Now, this particular line was taken negatively by the doctors. They said, yaar, hum kisi patient ko de denge, pata nahi kal patient ka insulin niche ho gaya, aur if it dies, then I am in soup. So doctors said, my existing therapies are perfectly fine, though it is a fantastic innovation, and company has done a great job. They finally got through preclinical, clinical, and the US FDA ने पूरा डेटा वेटा चेक किया, and they finally एक लाइन लिख दिया कि भैया आपको एडिशनल डेटा दिखाना पड़ेगा क्योंकि we are not sure long term इसका इम्पैक्ट क्या होगा. So the doctors immediately picked that up, and after 4 years, $2 billion was spent on the marketing. जो $2 billion Indian rupees है 15,000 crore रुपए, they spent on the marketing of this drug, and they could only generate 400 or 500 million dollars of sale, and the product had to be withdrawn. So even an innovation which seems that it is a good product, going to change the life, you don't know where the problem is. And a company like Pfizer, even after spending so much on the market research and trying to understand and lobbying with the regulators, etc., couldn't finally go through this whole process and ended up losing a huge sum of money. Even after getting the approval, even after everything was fine, the trial data was fine. So even an innovation may falter at any point. So in this backdrop, the philosophy and the licensing negotiations change. So coming to the difficulty, I gave these examples to understand prior, so that you know that while a person is trying to put across some fact, where is he coming from? Innovator बोलता है मेरा इतना मेहनत लग गया है, मैंने innovation किया है, it should reach to a level till it fails scientifically, market पहुंचना है, और company आ रहा है कि मैंने इतने सारे efforts लिए हैं, and I have seen things failing at different points in development process and even after getting approval. So this is the two ends of the negotiating table. Now, and as I mentioned, these are the, I have already mentioned higher risk, long-term returns and time to market longer. Fundraising is always difficult in the development process. That's why you need big farmers to come in. Then companies' perspective, they are always conservative. उनको लगता है कि हर मॉलिक्यूल फेल ही होने वाला है, because that has been their life. Priorities lies in quick return. उन्होंने यार जितना ये phase 3 का डेटा अगर दिखा रहा है तो इसका मॉलिक्यूल ले लो, because now we are sure कि मेरा रिस्क सिर्फ 100-150 मिलियन का है. We will end up paying more to this company because in the phase 3 का डेटा लेके आया है मेरे पास. मैं rather preclinical डेटा के मतलब एंट्री लेने के वजह I will prefer to get into phase 3 and pay more and be sure कि मेरा मॉलिक्यूल मार्केट में आएगा. Then internal competition within companies for research and development funds. Now this is a very important aspect. अगर कोई अपना technology किसी form, it is not this, any industry में, you have to choose the partner very carefully. If there are two parts, one is the company has a strategy to focus on that particular segment where you are doing research. कहने का मतलब है फार्मा में अगर मैं बात करूं कि डायबिटीज में वो कंपनी का इंटरेस्ट है क्या, आपने डायबिटीज का कोई सोल्यूशन लेके आए, अगर है तो डायबिटीज में दवाई बेचना चाहता है या डिवाइस बेच रहा है. सो यू हैव टू बी वेरी क्लियर. यू ले जाओगे, कंपनी इंटरेस्ट भी दिखाएगा एंड आपका एक लेवल के बाद वो प्रोडक्ट को छोड़ देगा. नाउ द स्टोरी डजंट एंड देयर. ठीक है, डायबिटीज में तो इंटरेस्ट है, मगर उस इंटरेस्ट के अंदर एक बहुत बड़ा चैलेंज होता है कि हाउ डू यू, is the company going to be seriously following my technology? Now if I have developed something, so company, is it going to take it? Because company also has that much resource, though bahar se lagta hai they have a lot of money, but that money is not adequate enough to fund all the research. So and when they take up a molecule or a research project, they take a 4-5 year horizon to come to a conclusion that it is worthwhile doing that or not worthwhile doing that. Like I was working for this French MNC and they had a very big team for HIV vaccine. It had a huge internal team and there were 7-8 vaccines they were working on that simultaneously. But after the couple of failures, and then they realized that we cannot make a vaccine against HIV, so they completely shut down the whole HIV unit. So if you go to that company now with the HIV vaccine, they will say, no, thank you. We are not even interested in that. Though in some point of time, they had a lot of funds available for HIV vaccine research. So it is just to give you an idea how things shift. And many of the vaccines were left in the middle because then company realized कि ये vaccine हमसे बनेगा नहीं, इसको अभी बंद करो सारा. Now, now, if you have technology, there are two basic ways you can take it to the market. One is to reach out to the established companies at different sizes and who fits into your idea about the technology आप market में किस तरीके से देखना चाहते हो and their interest and potential given the background मैंने बताया. So and for that you have to look at the established market functions and big markets, know how to manufacture. उसको पता होना चाहिए कि how to manufacture if they finally come through the trials, how to manufacture and capitalize it. And they should have capital. Very important. अगर नहीं है तो कहाँ से they will bring in the capital to develop it. So it is very important to look at their balance sheet. Everybody wants to do an innovative product, but they don't have the wherewithals to do it. And this kind of researches are intensive in nature. It might require international collaboration because आप कोई भी चीज आज के लेके आओगे, there are multiple IPs which are involved in taking a product to the market, and many of these IPs are not from India, for example, or from a country. So you have to travel, negotiate with other companies to get those intellectual property on board before you can commercialize it. So how do you negotiate and put this basket together? So it require capital to travel, to negotiate, to even do the basic business development before you can hit the market. And once you hit the market, you should have the money to push the product in the market. Just developing the technology means nothing because finally it has reached. It requires a lot of trials. It requires convincing. There might be adverse reports. You have to counter the adverse reports, and then slowly the technology grows to a level where it gets a normal acceptance and things start selling on its own. And they should have enough resources to protect the intellectual property rights because there might be, as you grow, it will start companies across the world with infringe intellectual property. I know for sure एक incident US में, there was a South African company, a small one. They had an innovative technology and their patent was infringed by a big pharma company. Now it was a clear case of infringement. Patent hai, infringe ho gaya. And this small company from South Africa went and challenged this guys in pharma company, and they said, "Dekhiye, you have infringed my patent." The pharma company, the team brought in the experts from IT, IP, etc., and they said, "Yes, so we agree that we have infringed the patents." Now it's anybody's guess. इसके बाद क्या होगा? क्या आप लोग सोच रहे हो कि हाँ लो जी we will be settling down and negotiating a price and getting the money, but it was the other way around. The pharma company said, okay, we have infringed the patent. The route you have is please sue us in the court. Now a small South African company don't have the wherewithals to fight a case against a big pharma company who has a legal team of 370 lawyers in US. वहां से साउथ अफ्रीका से टिकट ही उनका इतना पड़ जाएगा, 4 चक्कर लग गए तो कंपनी की हालत खराब हो जाएगी. So this is again one has to understand whom you are handing over the intellectual property. Do they even have a wherewithal to fight it out in the markets which are of importance? Now this is the important part, how the startups part. The startups can serve specialized hands-on markets, can maintain pace of technology innovation, that if you work in a spin-off or a startup thing, they have a more flexible team and are organizationally flexible. and may have a result in a long-term relation for the inventor. Unlike the bigger companies, may your technology is one in their basket. They are already getting revenues. The interest is to save their existing products. They're fighting a battle in the market with their existing products, so they're trying to add another one. And out of that another product, yours is in the list of 10 products that are in development. But in the small startups, yes, they may not have that enough capital, but rest of the resources are very accessible to the inventor. And many a times the startups have developed the product and has been successfully taken it to the market. And one of the major successes have been AbbVie. You may have come across this company. It is now the second largest company. It started off, has grown and grown on the back of a single molecule drug, which is called Humira. And today it is, I think, I may be wrong, around $26 to $30 billion is what they're making from that single drug. So startups can also become giant in even a complicated market like pharmaceuticals or electronics, despite you have technology giants like Microsoft, Google, who are innovating every day. So there still remains a scope, and even a complicated and highly regulated market like pharmaceutical, where it is believed that only big pharma will be able to take on. So it is a good possibility. Now, though technology काफी बनती है, which is well protected, patent grant हो गया, सब हो गया, though the slide says 1 to 2% of technologies, and this 1 to 2% is high because a lot of IT and electronics technology ka success rate is much higher compared to pharmaceuticals. So 1% is a very high rate of success for pharmaceuticals. So, but actually even 1% becomes successful startup companies. Now we had been, you have to understand what is the implications for the inventor for taking decisions in the licensing process. The licensing or sale to the third party company, the big companies, is there is less hassles. It's a hands-off path. मतलब हमने दे दिया, आप संभालो इसको और जब होगा हम ले लेंगे. So if a researcher doesn't want to get entangled in the commercialization process, this is the best one. But it also leaves you with less opportunity of return, which I mentioned earlier. Then we have less personal and financial exposure and risk, and also less control and ego identity. मतलब आपका उस टेक्नोलॉजी में कोई कंट्रोल नहीं रह जाएगा. Once you have given, you get your lump sum fee, जो valuation में एक price fix हो गया, you get your money, they invest money, they take it the route they want. आपका कोई risk नहीं है, कोई exposure भी नहीं है, आपको अपना पैसा मिल गया, and whatever they do. But again, then you are completely normally blacked out in this whole process. The product then becomes the company's. Many of the researchers who have given these products to bigger companies, they never come into the forefront unless and until the company wants them to. But if you are a participation in a spin-off, it might require a demand for a career shift. You have to get involved with those companies, but then you are again has a potential for a huge gain. अगर वो successful हो गया तो सारा आपका, अगर fail हो गया तो पूरा risk आपका. Opportunity to stay with the invention throughout its life cycle. Then you are along with that invention because it was a baby and you can give it direction the way you want it. So then दूसरे के हिसाब से नहीं चलना पड़ता. I skipped this because I am this is the how you form a spin-off. The steps, I think we're running out of time. I will skip this. Yeah. Now, एक important slide है. Many people who commercialize actually don't understand what goes inside the big pharma. उनको लगता है इतना time क्यों लग रहा है, वो decision नहीं ले रहे, वो लेना चाहते हैं, नहीं लेना चाहते. एक तो fact है, they want to delay the decision to the farthest. कि जितना late उनको लेना पड़े decision कि ये product हम market में ले जाएंगे, उतना उनके लिए बढ़िया है. So that is one part which is they try to delay it maximum and still keep you engaged. They don't want to let you go and neither they want to negotiate. The best model उनके लिए क्या होता है for a big pharma or big companies is they start dealing with startups. They expect them to bring the technology to a level and then they buy out the startups. So that is the best model for them, safest thing. As you see today, Pfizer bought out the vaccine from BioNTech, which was a German startup, a small size company who developed this, and then Pfizer took it over and developed it across. Similarly, if you see the other vaccine, which is you might be seeing was developed in a university, Oxford University, given to Astra for a development phase, and they quickly the incubating Oxford incubation did part of it, and then Astra used the Oxford incubation and their process team developed the process, regulatory approval liya, and then again the problem of Astra was they never manufactured vaccines. They didn't have the facility. फिर उन्होंने क्या किया? They went out and found 14 manufacturers across the world with different capacities, out of which we all know Serum Institute in India. उनके साथ MOU were the initial phases, and this vaccine was finally manufactured by a third company. So there were two vaccines which took two different routes to the market. So ऐसा कुछ एक process नहीं है कि यही route होता है. It all develops. It's all part of negotiations. It all part of the how situation develops. But all products will have to, in a company, go through this particular set of teams. And each of the team is a roadblock inside the company. मैं इनको roadblock बोलता हूँ. I have been party to the business development team. They are the people who try to internalize the technology. They scout around, and many big companies call it an external R&D team. They look for these technologies. आपके पास all the incubators and जो innovators हैं उनके पास जो technology है, they engage with them and then try to find out what is this technology all about, and then they internalize, and then the internal teams जो है, they all have a say on a technology. BD का role वहाँ पे खत्म हो जाता है. It goes to the IPR team. They look at the patent aspect. Patent aspect में 2-3 key चीजें देखी जाती है. One is what is the patent validity, कहाँ protected है, what is बोला आपका patent कितना strong है. Then what are the other patents that are required? Is this patent infringing other patents, or while in the development process we are getting blocked out by any patent? जैसे मैंने वैक्सीन बनाया और मैं एडजुवेंट मेरा पेटेंट ब्लॉक्ड है, तो मैं वैक्सीन बना ही नहीं सकता क्योंकि कुछ और पेटेंट मेरे को कहीं से ब्लॉक कर देगा. So is there any blockage on the way? Then comes the legal team. Legal team negotiates the legal aspects of the licensing and agreement. That means क्या jurisdiction होगा, क्या geography में कौन सा law follow होगा, किस country का law follow होगा, कहाँ पे arbitration होगा अगर दोनों dispute होता है. Cross border में ये बहुत बड़ा issue है. If you are dealing with a UK based company and you are an Indian entity, कौन सा jurisdiction follow होगा? Like in case of Serum, the jurisdiction is UK, so all cases will be fought in UK. तो ये बड़ा this is the complicated part where the legal team puts in a lot of roadblocks, as many innovators see it as roadblocks, and it has to be overcome. Then obviously आपका एक claim है this as success. Then the marketing or many companies have the new product team who takes a call कि भैया this product has a potential. 5 years or 8 years or 10 years बाद ये product आएगा, 10 साल के बाद we'll see a good potential. They also analyze कि what other companies are doing. If we seriously need to look at this product कि Pfizer क्या कर रहा है, Glaxo क्या कर रहा है, Y क्या कर रहा है, इंडिया में क्या हो रहा है, चाइना में क्या हो रहा है, because once 8 साल का investment रहेगा इसके research के ऊपर, and 8 years of investment on research, marketing, regulatory and all that clinical development, all that thing will be invested. So it shouldn't be कि 8 साल बाद हम वहाँ पहुँचे and then we realize there are better products available in the market and this whole exercise is futile. So this team has to take a 8 or 10 year long vision when the product is going to be launched and then beyond, how the money will be realized. Then comes a clinical development team. who takes a call on इसका अगर हम ट्रायल करते हैं, this is specific to drugs दो, अगर हम इसका ट्रायल करते हैं तो इस ट्रायल में क्या क्या रोड ब्लॉक्स आएंगे, कहाँ से मैं पेशेंट लाऊंगा, कि अगर मेरे को किसी ड्रग को प्रूव करना है दिस इज एफिकेशियस, आई नीड अ पेशेंट, हाउ विल रिक्रूट द पेशेंट, व्हिच कंट्रीज आई एम गोइंग टू मार्केट, वहां पे क्या मेरे को क्लिनिकल डेवलपमेंट, इट्स अ वेरी कॉम्प्लिकेटेड स्टोरी. सो दे टेक अप व्यू ऑन इसका क्या मैं क्लिनिकल डेवलपमेंट इजीली कर सकता हूँ. देन ऑब्वियसली द स्केल अप टीम, बायोटेक्नोलॉजी में ये बहुत कॉम्प्लिकेटेड है, दो ड्रग्स आ जाते हैं, सब कुछ है, बट वी कैन नॉट स्केल अप इन मेक इट इन लार्ज क्वांटिटीज, स्पेसिफिकली इन मोनोक्लोनल एंटीबॉडीज जो आप देखते होंगे मार्केट में, और इवन वैक्सीन्स. इट इज अ वेरी कॉम्प्लिकेटेड स्टोरी टू स्केल अप. एंड फिर many a times I have seen in my whole life while working for this, the scale up team has rejected the technology even there is very strong potential of reaching the market based on all other data, patent अच्छा, सब कुछ अच्छा, टेक्नोलॉजी अच्छा, बट स्केल अप टीम ने बोल दिया कि हमसे ये एक लेवल पे स्केल अप नहीं होगा. एंड बिकॉज वी कैन नॉट मैन्युफैक्चर इन बिगर नंबर्स, देन वी द प्राइस ऑफ द प्रोडक्ट वुड बी सो हाई दैट वी कैन नॉट सेल इट. सो देयरफॉर this is also an important time part of evaluation. Then internal research team, wo to aata hi hai because it's a new technology coming in, so they take the research position on the data analysis ye karti hai. Finally the regulatory team, regulatory process pehle se hona chahiye ki aapka jab डेटा रेगुलेटर के पास जाएगा, हाउ रेगुलेटर इज गोइंग टू व्यू द डेटा, आर दे गोइंग टू अप्रूव इट. एंड वी हैव ऑलरेडी शेयर्ड एग्जांपल ऑफ एक्सुब्रा, जिसके अंदर आपका डेट सब कुछ होने के बाद में रेगुलेटर ने एक लाइन लिख दिया, वेयर द रेगुलेटरी टीम फेल्ड टू एनालाइज एंड इन एडवांस दैट ये प्रॉब्लम आ सकता था रेगुलेटर में की तरफ से, एंड द प्रोडक्ट फाइनली फेल्ड इन द मार्केट बिकॉज वो एक राइडर लग गया. प्रोडक्ट में कोई एडमिसिबल चैलेंज नहीं दिखा था जब वो कि डॉक्टर्स ना लिखे, जस्ट एक कॉशन जो लिखा हुआ था जिसकी वजह से डॉक्टर्स ने पूरा उसको अवॉइड कर दिया. इट वाज अक्रॉस यूएसए एंड यूरोप. एंड फाइनली द फाइनेंस टीम हु इज गोइंग टू साइन द चेक, कि आपसे जब डील हो रहा होगा, टेक्नोलॉजी ले रहा होगा, व्हाट प्राइस द टेक्नोलॉजी विल बी, एंड दे हैव टू. सो इंटरनली कंपनी के अंदर इतने लोग इन्वॉल्व होते हैं आपके टेक्नोलॉजी या आपसे जब लाइसेंसिंग नेगोशिएशंस होती है और उसका इम्पैक्ट को असेस करने के लिए. सो दैट्स व्हाई इट इज अ वेरी ब्यूरोक्रेटिक प्रोसेस इन अ बिग कंपनी, एंड इट मे टेक एट टाइम्स 2 to 3 years if it's a complicated deal. एनी टाइम 6 to 2 साल लगता है, डिपेंडिंग ऑन द कॉम्प्लिकेशंस, फॉर अ deal to finally close and the money to come in and the development process start further. I think I have just shared some of this. Okay, there are quickly I will run through. There is exclusive licensing. Licensing दो टाइप के होते हैं. Exclusive, where I give the rights, where one company organization gives the rights to one company, एक ही बंद करेगा. And non-exclusive होता है, I can the innovator can give the license to multiple companies. Yeah, another important thing is cross licensing. I must mention here, क्योंकि many a times there are conflicts in the IPs आ जाता है, so both companies come together and grant license to each other. There is IPs, I am infringing one IP of a company and the other company has a possibility of infringing mine, so we cross license each others. But इसमें company के view में क्या होता है, they try to create a monopoly. भाई तुम यू स्क्रैच माइन, आई स्क्रैच योर्स, हम दोनों मिलके माल बेचते हैं, एंड वी ब्लॉक अदर्स आउट. सो क्रॉस लाइसेंसिंग इन वन वे ट्राइज टू क्रिएट अ मोनोपोली, बट द अदर साइड आल्सो इज दैट दे अवॉइड लिटिगेशन. दोनों ने एक दूसरे की लाइसेंस ले रखी है, तो देन दे डोंट फाइट एनी केसेस इन द कोर्ट. Yeah, how do you price the product? टेक्नोलॉजी, जिसमें मेन पार्ट होता है, एक लमसम फी मिलता है when you get some money when the license is closed, if it is from the university to a company you get some initial amount, which you call as lump sum, and then subsequent to that, we get royalties. Ki bhai, itna maal bikega, so as part of the sales, you get certain amount of money, which is called royalty, and that can be linked to the revenues or net profit or even a per unit sale. Itne piece bike to itne paise milenge, and that is all after subsequent closure of successful completion of the regulatory process jab wo market hit karega. So ye royalty is basically a risk sharing with the company, and iske andar I have mentioned this in bits and pieces. Yes, these are the various terms which are, while you draft a license, how many the different angles you look into this while you draft a license, from royalties, which I mentioned, the taxation, the currency in which the deals will happen. कि अगर cross border है तो Indian rupee होगा या dollar में dealing होगी, who takes that risk. फिर political risk भी है किसी licensing deal में, which we see specifically nowadays in vaccine, जहाँ पे Serum Institute का license agreement has created a political misunderstanding. मैं उसको misunderstanding बोलूँगा because licenses are a very secretive thing and politically लोगों को लग रहा है कि इंडिया से वैक्सीन चला गया है, but actually this was part of an agreement because Astra gave that technology and as part of that it was give back to Astra. So it was a give and take process. तो ऐसे चीजें हो जाती है एक लाइसेंसिंग एग्रीमेंट का फॉलोआउट्स में. सो ये सब while you work this out, उस ड्राफ्ट के अंदर मेंशन होता है कि क्या किस रिस्क को कौन एड्रेस करेगा. कि अगर पॉलिटिकल रिस्क है तो who is going to be responsible for addressing that, and if there is any issues on exchange controls or dollar exchange बढ़ गया या change हो गया या घट गया, so who is going to address what, and how everything is drafted as part of those agreements. Yeah, so
Sir, I think it's last slide. Okay.
yeah, absolutely. So I am absolutely.
Actually, we have our next speaker.
Yeah,
So-
sorry, I just overshot by
No, it's okay.
12
Sir.
minutes. Thank you. It was great to address this audience.
Thank you so much, sir, for the joining in the very quick notice. So we'll move to the next session.
Right. Thank you.
Yeah. Thank you so much, sir, for your time. So we'll move to the next session, nurturing and protecting IP in the university, from the Dr. Yashwant Dev Panwar, sir, head at the PFC TIFAC, Government of India, New Delhi. He's MSc Physics from MDS University, Ajmer, Rajasthan. Specialization in the microwave electronics, and MTech in the future studies and planning from Devi Ahlia University, Indore. His doctoral research is in progress from the IIT Delhi on management of intellectual property. So he's presently heading a patent facilitating center. He has been working for more than 21 years for PFC in the different capacities. So he contributed in involving the important program of DST like Kiran IPR program. He also performed an internship on technology transfer at NIH, USA, and also taken training at EPO and Japan Patent Office. So we welcome you, sir.
Yeah, thank you, JK sir,
Yes.
for nice introduction. I could see Dr. SK Mitra. Good afternoon, Mitra sir. And I was listening to a lecture from Jitendu. I think it was a comprehensive one on technology licensing. So he made my task easier. So I think we are running late by 20 minutes. So I'll try to save 10 minutes for you.
Thank you, sir.
Because I think I don't want to come between lunch and participants. So can I share my slides now?
Yeah, yes, sir. You can start.
Is visible there?
Yeah, it's visible.
Okay.
Just in the slideshow mode. So
I'll turn it to go.
yeah.
Okay. Thank you once again for joining for the session on nurturing and protecting IP in universities. I think by now you are well aware of patents and other forms of intellectual property rights, but there are some lectures tomorrow also on other forms of intellectual property rights. But I've seen the program, so I feel that now at this time you're well aware of patents at least.
Sir, it's not showing in the slideshow mode. So
It's not showing? What
no.
is the issue?
But
I'm stopping sharing.
Yeah.
Okay, one moment. So what I do, I share entire screen now. In place of
Okay
sharing.
then.
It's not allowing me to share the entire screen.
It should be okay, sir, if you just present it in the normal mode and make the slide ratio bigger.
Mm-hmm.
So that should also work.
Is it seen now?
Yes. Yeah. So just it's I think 65%. So we can elaborate.
Yeah. Now it's full slideshow mode. No.
No, sir.
Why this is? The slides are changing now.
Yeah. It's okay, sir. So we can proceed. It's
Okay. So what I can do?
Yes, around 70% it will be work. Yeah. It's perfect, sir.
Okay, just give me remove this background as well as. Now it's better, I think.
Yes, sir. 80%. Yeah, better.
Yeah. Okay. So I think there's issue in sharing slides, so we will go in this mode. So thank you very much. I think you had detailed deliberation on how to license patents just before this, and I think entire universe has been exposed to you by Jitendu. So now you can decide the stars movement and predict your future and how you should do your research. I think that was a very comprehensive one, different nuances, and those are very important to understand before nurturing research and development in the university, as well as nurturing intellectual property rights to protect those all those things which you are creating in the university. So I think let's start the business right away. And I firmly believe that in last 2 days, since yesterday, you have been exposed to patents in details, but I would like to reiterate few basic component of a patent, or in other language, I would say nature of patent. All you are aware that patent is strictly territorial in nature. Okay, patent is strictly territorial in nature. So it means it is valid only within the country of a grant. So if the Indian patent is granted, it is valid in India. If it is granted in other countries. So if you seek protection in multiple countries, you have to file in different countries. And then there is a life of a patent, which is maximum 20 years. And this also subject to various conditions, such as renewals or grant or not being challenged and refused. And Other important characteristics of this is validity of a patent. It can be challenged at any point of time. But what will help you in nurturing IP and nurturing research and development within your institution is to look at patent document. So all the patent applications which are filed with the patent office for different countries that get published as such. So the complete technical details of invention get published as a patent publication at every stage, whether it's a filing stage, whether the queries posed by patent office with regard to novelty and inventiveness, or the post-grant publication, or any other correspondence happens with the patent office by the patent holder or a patent applicant or other interested parties who wants to oppose or and then all licenses as mentioned by Jitendu, all those licenses and technology transfers also get registered in the patent register. So that forms a very important technical information for a university and a patent applicant, maybe university or a startup or industry, large, small, whosoever is owning a patent or would like to see what others are owning, and that's very important. And it is well researched and documented that 70% of this information, the technical information which get published in patent document, never get published anywhere else. So if you are not looking at this information, then you are missing out very, very important input into research and development in institutes of higher education. So, and then what kind of rights you are getting? The patent give rights to stop others from making, using, selling, importing. So doing all those activities are debarred without the permission of patent holder. But here in higher education, I would like to emphasize and make one point that all the patent and all the technical details in a patent document can be used for research and teaching purposes without seeking any permission from the patent holder. So when you are nurturing your research and development, the whole of a patent literature is available to you to conduct further research. So there is no bar or no restriction posed by patented invention or a patent grant of patents on certain invention within India also. So all those technical details, which is in valid patents, expired patent, or patent under dispute, everything is available for our universities and academic institutions for two purposes. One is to conduct research and to teach our students. So we, as institutions, should make use of that particular provision and thing is available to us. And once we get into reading habits of these patent documents, then we will know how you can get patents, what kind of claims you can make research done by your university and institute. So that is very, very important. And so that's understanding I wanted to reiterate before we go and talk. So what is this patent all about? It's the patent from the technology perspective. It actually tells you that what is new in that particular product or what is new in that particular process. So that is really made known by the patent document. Give me. So Hello. Yes.
Yes, sir.
Yeah. Sorry. Yeah. Okay. And then what all improvement takes place in those technologies are also part of these patent documents. Are you able to hear?
Yeah. Yes, sir.
Okay. And then as far as concern of legal rights, who is owning patents, where it is valid, and when it will be for all for commercial exploitation. So that's, I think, previous speaker made very important point that while commercializing and utilizing, putting your technology into market, what are other blocking patents which can stop developing the product based on your technology because of the other patents was very important insight. I think you take, I just wanted to reiterate that from that. So now let's look at this. Let's look at this as a whole body of a knowledge. And in each given point of time, this body of knowledge is actually receiving a lot of new knowledge in different subject areas, be it be history, be it be psychology, be it be economics, or be the science and technology. So knowledge, body of knowledge is ever growing, and patent plays a very important role. But other intellectual property rights, if you're writing a book, copyright, music, so design, creating design, so all other IP plays a very important role. But the majority of a focus of university IP may not be on a trademark too much, but definitely a design registration, patent filing, new plant varieties in agriculture universities. GI again may not be very important for universities, but the universities which are adjacent to areas where some GIs are practiced, they can help artisans in associations in protecting and exploiting IP, or particularly GI. So that limited role can be assumed by academic institutions, but mostly IP from academic institution at a large volume is copyrightable materials in the form of paper, publication of papers, books, and other forms of publications created by these research institutions, be it the question papers, etc. So majority of IP in these institutions forms copyrightable material, and then comes innovation, inventions taken place in the laboratories of these institutes of higher educations. So that add significant knowledge, the technical knowledge, to the pool of that particular institution, as well as the whole global knowledge on technical information. So having understood these, when we talk about patents, there are some language issues, protection issues, and technological issues. I'll not go into these, but to nurture intellectual property rights in academic institution, a regular audit must be conducted to really understand what the institution has there in their campuses in the form of intellectual property rights, what all intellectual property rights they have to take license, what all intellectual asset they can sell, what intellectual asset they can rent or give a license to other institutions. So basically understanding about or record of systematic record of your asset is very, very essential while nurturing property rights. So I would advise a periodic audit of intellectual property rights within the Institute of Higher Education, and to do that you need an independent agency, or I think IPR cell to be established in academic institutions, and they should actually keep all these records and help auditing agency to really come up with an audit report. So based on those reports, you can really understand well and nurture well IP within the institution. It generally means evaluation of a person, maybe organization, or any system or a process, enterprise, or your laboratory, etc., etc. So it means an evaluation. And why it is to ascertain validity and reliability of information coming out of it actually enforce and help you evolve your internal controls. So by evaluating your internal control system, so how your IP has been protected in time or not, has it fall into the public domain by way of publication, so patent could not be filed. So to evaluate internal controls of institution, I think periodic IP audit is a requirement to improve and enhance IP output of any institution. So, and it is to be done independently because internal evaluation may be a biased proposition. So what all you should do in nurturing intellectual property right in your institutions by way of auditing IP within your institution. So it is always advised that you periodically review publication by the faculty. If it is done before publication is made, and these reviews are supposed to be very quick because publication cannot wait, people cannot wait for a long. So is there any patentable subject matter is part of this publication which is going out of the institution to be published in research journals? So if the IPR cell of the institute take care, then patentable or design registrable or any other form, any material which can be protected in other form is very, very important and can be identified, and actual steps can be taken in order to protect and finalize things. Then it's very important to take stock and review of PhD theses. And if it is reviewed before they are put into libraries of the institutions, so that is very, very important. And these research publication, if they are periodically reviewed, then the leakage of intellectual property right can be stopped and the rightful protection can be obtained on these patents. Then whatever research projects sanctioned to faculty from various funding agencies, those need to be reviewed, and IPR guideline and IPR understanding between funding agency and your university need to be understood, and accordingly protection of intellectual property right to be sought. So those responsibilities in some cases can be given to funding agencies, and requirement of funding agencies to be fulfilled or a condition of university to be enforced in such projects in order to own and nurture intellectual property rights from these. And the book written by the faculty, so will it be in the individual names? So there has to be a policy of institute, how you can own intellectual property rights, how you can really share intellectual property rights with the institute, with the faculty, with the students. So those can be handled by policy matter. And if you have too many restrictions and not giving adequate freedom to faculty and students in owning intellectual property rights, the creation may hamper. So there has to be a balanced approach in the policy. So that really is an essential part of it. And then not only PhD thesis, ongoing PhD work and project work also to be examined for the possibility of obtaining patents and all. So who will what other things? Who will do all these things? So there has to be, I think, IPSL to nurture IP in the institutions. And that should also take stock of IPR application filed by different faculty members, take a stock of design registration and filing of other intellectual property rights. They should prepare an inventory of IP and IPR, and what kind of returns accrued to the institute from different forms of IPR and protection of IPR. And there has to be policy update with regard to intellectual property rights. So that should be a periodic activity. And there has to be a system to facilitate research and the creation of legal protectable invention. So there has to be a facilitation mechanism within the institute. So there may be IP cell or maybe some cell within the institute who can which can promote these activities for doing appropriate research, utilizing patent information or IP information while conducting research and development, and come up with a protectable invention. So those steps should be periodically taken by institute. And then it is very important to appropriately protect IP is to review different sanction letters issued by funding agency to determine who will own the intellectual property rights, and will give insight in all future collaboration to have an appropriate conditions of research and development. So I think if these steps are taken by our institutions, will actually help in nurturing intellectual property rights. I think these are the technical steps, but I'll not go into now details of how you can do systematic innovation using, so I'll skip all these things, and I think I have taken already exceeded 10 minutes of my talks end, so I'll finish this here. I have made point how you can nurture intellectual property rights in the institutions. So I would rather prefer if there are a couple of questions which I can take on this from participants.
I think we do not have any questions right now. So if we have, so we can forward to your mail ID, sir.
Yeah. Okay. Okay.
Yeah. Yeah. Thank you so much, sir, for your joining.
Yeah.
We have 3 days program, so tomorrow also we have.
Great. All the best.
Thank you so much, sir. Yeah. So we have with us Dr. Susil Kumar Mitra, sir. Yes, sir. Welcome, sir. So he has done MSc, PhD, LLB, and he's working as a former Deputy Controller of the Patent and Design, in charge of Design Wing of Patent Office, Kolkata, Government of India, and he has 40 years of experience around professional and teaching experience in the IPR in the different capacity. So he also worked as a visiting faculty of IPR in the different national and state level institute like IIT Kharagpur, NIT Patna, RGNI IPM Nagpur, Government of India, West Bengal Council of Science and Technology, and NIPER, Government of India. He is engaged as a patent advisor of Institute Technology Management Unit, Indian Council of Agriculture and Research, Eastern Zone, and Indian Institute of Engineering Science and Technology, Shibpur, Howrah. Dr. Mitra specializes in the IPR patent system, and they're useful in the scientific community. GUJCOST welcome you, sir. You are on the mute, sir.
I am very much thankful to the organizer for giving me an opportunity to say about process for registration of design and the impact of the design, one of the intellectual properties in the industrial development and for the benefit of the science and technology and faculty as well. So my previous speaker, my friend, my colleagues, you can say, and my brother, Dr. Yashwant has given an outlook about the value of the intellectual property, particularly patent and other limbs of intellectual property right. So I am going to specialize on design. Before going to, I am going to my slideshow. I think uh, just can you see my slide?
It's loading, sir.
Okay.
Yeah, we can
Yeah.
see.
Okay.
Yes.
So my topic I have selected today, the emerging trend in design registration, and it is a marketing tool for industry. You know very well that patent is a queen of IPR, but it is very difficult to obtain patent because it requires a lot of time, money, and skill. And also the after obtaining patent, technology transfer working as another area, and which is very not easy for the individuals or the scientists or the innovators. They are going to license with the companies, and only company can go for large scale productions with the patented technology. But design is one of the intellectual property rights which is very easy to earn or obtain a registration. And I will tell that only 6 months time is the statutory time is given in the act to obtain registered design if there is no other requirements in the law. And also I can say for the micro, small and medium enterprise, or also many institutions are working for designing their product. Why design is very important, why registration is required, how it can be done, I will try to say something on that. But I don't know what only within 20-30 minutes it will not possible for anyone to cover all the design aspects, but still I am trying so that at least I can create some motivation for working for creating design and getting registration for design. Now I am coming to the next slide, that is what is industrial design. Industrial design, already it has been mentioned that it is a category of IPR, and design system focuses only on the aesthetic features of the article. Because whenever I am going to the market for purchasing a material, there is a technology, but behind the technology, only the views are coming which can attract the customer side. Whenever I am selecting a television or mobile or a bottle or a container or any article, the aesthetic beauty also is playing a key role for selecting my product apart from the technology part. And that the aesthetic beauty on applied on the article only can be protected under the industrial design. And it covers the visual appearance, relevant aspects are the shape, configuration, surface pattern, color, line, combination as applied to the article, which creates an impression of the aesthetic impression on the sense of the site for capturing the marketing of that particular article. Why? Then the industrial design is a product of the overall form and function. Every product or every article has some functional part, but the overall function, if we consider, we should consider the aesthetic beauty of the product also. So in business, designing a product which generally implies the developing the products functional as well as the aesthetic features, taking into consideration in the issues. So such as products marketabilities, cost, cost of manufacturing, transportation, short storage, repairing, disposal, everything, it will come under the point of discussion in design, and it does not relate it to engineering design. Always you keep in mind the engineering design only can be protected under copyright, not by the Designs Act or by the registration of the design. So the importance of the industrial design is making the product attractive, appealing to the customer, that is the end user, and maybe it may be considered as an unique selling point. So industrial design adds value addition to a product. The product may have some functional, may have some technological part, but the industrial design adds the value to the product, and by against you are getting a fair return on investment, and it is a business asset, and it creates a fair competition in the market over the competitors, because two competitors are producing the same product. You are also producing the same product, only difference will be made the aesthetic beauty of the product, and then only customer will choose your product. So design is an important part also to create the market leadership. So now coming to the another issues, that the whenever I am going to the market, 20 years, 30 years down the line, we are thinking for the price of the product. Now today we are talking about the quality, whether it is durable, we can use for a long period. We are generally not selecting our Chinese product. Why? Because Chinese product, the quality is very poor. And for that, within 5 or 6 months, that product cannot be used. But Indian product has a long life, 2, 3, 4, 5 years you can use. So that today we are thinking about quality, but tomorrow the market will be controlled by a aesthetic beauty and the design. So design is a good marketing tool for the purpose of the capturing the market and creating the market leadership. So now the slogans are there in the Time magazine. The when companies are competing at equal price and functionality, the design is the only difference that matters. So when the function is same, design is different, and the best design is going to be selected by the customer. So you are getting the marketing opportunity if you can create good design over the same product having the same function also. So now I am coming to why registration of design is required. Because registration of design, if you don't do, anybody can use your design, apply to the product, and you cannot get any compensation. You cannot go or sue to stop the production of the same kind of product which is produced by your application of mind. So to protect any new original shape, configuration, surface pattern, combination of lines, colors applied to the article, which is your creation, which is the creation of the human intellect by way of registration, is a must. And to prevent the imitations of the creator's designs. So if you don't register, if you only use it, like patent, if you just publish it, but you are not creating any patent on your invention, then anybody can use. So here, if you don't register, anybody can use your design. You cannot get any benefit of your design. So the registration is must, and the requirement is that protect any new original shape, configuration, surface pattern, combination of lines. So it is very essential, because everything is your feature, and that feature you are applying to the market article. So to prevent the commercial exploitations, creators design by the third party without the proprietor's consent is the benefit, and to obtain the bona fide reward for commercial exploitations, and to increase the interest in innovating more design in the field of consumer products, particularly whenever you are getting reward in the form of monopoly of right and licensing your right to make the product more and getting market leadership. So now the thing is that application. If I consider the application, if you consider the small scale industries product, from the shoe chappal to toothbrush, toy, fan, in everywhere you can find the different type of designs, and this design is registered under different class. Patent is not registered under different class, but trademark and designs are registered under different class. Whenever you are producing a footwear, that will come under one class. If you produce a container, that will go to another class. If you produce agricultural equipments, that will go to the another area. So every product is classified under Locarno classification under design. And the medium scale product, if you consider, that is washing machine, refrigerator, television, computer, which is mostly coming from the big industries. They are also going for registration of the design. So design is the unique tool for the small scale industry as well as the big industry also. It is not that only micro industries only will use this kind of tools for getting market leadership. The big industry also is going for registration for their product under design registration under Design Act. So if I consider, just I am giving some overview view of the some article, you see here all the products, consumer products, everyone is using his house these products. You see how looking good, and this design also creates the lifestyle product. If you use a product which is very good design, then your friend or your relatives will ask from where you have purchased it, because it looks good. So it is also calling the lifestyle product. So not only the consumer product, if I go to the pharmaceutical product, all the pharmaceutical industries, whenever going to manufacture the packaging materials, they are giving their unique design in their product, so that from that packaging material, any purchaser, any end user can understand to whom or from which company this product has come. And if we look at just a multinational company's product and the generic industry's product, or a small scale industry's product produced by pharmaceutical product, from the packaging materials, container, box, sachet, you can understand what is the difference of those products, how the aesthetic beauty of their packaging material they are using for delivering their product. Though that is not the active material. Your active material else actually will go to function. But to create market leadership, they are giving the good marketing and good design in their packaging material, so that everyone can understand this is coming from a very genuine and big industries. Okay. Not only that, if I go to the textile and jewelry, the textile industry is always changing their design, because life period, though it is 15 years for registration, but design in textile all maximum last about 2 to 3 years. Thereafter it is changing. So always textile industry is going to produce different kind of designs, different kinds of garments, shape and configurations and patterns, so that they can capture the customer side. Even in jewelry industry also, now the girls are not going to purchase gold materials. They are now going to the shop and purchasing every day almost different kinds of ornaments, which are made of stone, metals, and so on. So why? Because it looks good. It can be matched with my dress, so I can change it. So the jewelry industry and the textile industry, the design also is very important tool for creating new design. Even if you are going to export any product, textile product or jewelry product, if you register it, then it will be very easy for going to export your product in other world also. So now I'm coming to the, if I go to the statistics, though USA is a very strong country for innovation, Europe is a very strong country for innovation. They are going to file more and more applications today. But in India, the patent filing is very poor. But if we look at the statistics of the design, that the major applications in designs are coming from the Japan, China, and Korea, that is Asian countries. India is also part of that. Though India hardly 12,000 applications we are receiving today. Previously it was 8,000, 9,000, 10,000. Now it is going to move 12,000. But still I can say at least the why Japan, Korea, and China is going to emphasize or the focus on the design, because they know very well to create the market leadership, only functional improvement is not the major unit, the major part. Only with a very short time, within a very short period, we can get registration of design and can create the market leadership if both the products are going to function same on level. So only by way of design, I can change the beauty of the product and I can get the world market also. So Korea, Japan, and China is going to who apply more and more design globally than the USA, Europe, or the other countries also. Now, if I go to the definition of the design, what is designs under the Act of 2000? The design mainly is a feature. Why it is a feature? Because it is a feature of shape, configuration, pattern, ornament, composition of lines, colors, and these features are applied to the article. It may be applied in two-dimensional. It may be a bed sheet. It may be a bedcloth, curtains, or in a dress, or it can be in three-dimensional by mechanical process, manual process, or both, chemical or separate or combined. But it should be how it can be judged, how it will be examined by the examiner of design. It can be seen only in the eye. Eye is the only thing, and that it should be judged by the eye, whether it looks good or not. But it does not include any mode or principle of construction, because that will go to the functional part. And for that, it can be covered only under patent. So the mode of principle of construction cannot be covered under design. It can be protected only a patent, and does not include any trademark or any property mark. What is property mark? Property mark means the Indian Railway, Indian Airlines, all the property mark. So the property mark should not be registered under design, and also artistic work which is defined under Section 2 of the Copyright Act. So these are excluded from the design registrations. So designs only is the feature applied to the article two-dimensional or the three-dimensional, and that should be solely judged by the eye, and which should be appealed to the eye. That is the consideration for registration of the design. Now, if I go to the article, because you see, in the world, Locarno classifications, or if we look at the registration of design globally, we have mentioned the article. No part of the world there is a definition of the article. Because in India, whenever you are applying any design, that should comply the requirements of the article. We cannot register any icon. I cannot register any only pattern, but that pattern should be applied to a tie or a cloth or anywhere. Then it will be registered under that particular class. So article means the article of manufacture, any substance, artificially or partly natural, and includes any part or article capable of being made or used solely separately. What do you mean by that? Say for a bottle. Bottle has the two parts, bottom part where you are keeping water, and one PP cap is there to close the bottle so that water cannot be spilled from the bottle. So if anyone is manufactured two things separately, the cap and the bottom part, then it can be registered separately. Otherwise, we will register only a bottle with cap. So you have to understand that whatever is registered, that should be a complete product, or it can be a part of the product, but if it is made available to the market separately and manufactured separately and sold separately, then only it will be the subject matter. Otherwise, we will say that you combine it and claim the combined product only. Now, if I go to the definition of the set of the article. Set of the article also can be registered under design by a single application. What do you mean by set? Set means say cup set, say or a sorbet set, or a glass set, where the set ordinarily sell or intended to be used together. Whenever I am going to purchase a coffee set or a tea set or a sorbet set, then always we have to purchase the total material. That is the 6 plates, 6 cups, and 1 container. So having the common design and same general character. So then, though it is different, but as because it is sold as a set, then it can be registered under a set also. So now I am coming to the original. How we are considering that design is original and new. Original means it originates from the creators of such design, includes the cases where the design may be old themselves, but application is new. I am giving the example of the Taj Mahal. Taj Mahal, the design is everybody's known, that design of Taj Mahal or Charminar Tower. But if someone is making a paperweight of Taj Mahal, giving an unique shape of Taj Mahal in the paperweight, or a photo frame, or a say article for keeping in the room, the small Taj Mahal. So that can be as a gift material. That also can be registered under design. Though Taj Mahal is not, its design is known, but the application of the external shape and configuration of the Taj Mahal or Charminar is applied to first that creator as a showpiece. So in that case, that can be registered under the particular place as a design also. So now I'm coming to the copyright. The design means, already I have told you, it is a feature, and it means the exclusive right you are getting whenever that feature is applied to a design or an article, and in a particular class it will be registered. And this registration is given for you 10 years, and thereafter 5 years you can get registration. That means total 15 years monopoly of right you can have for a registered design. There are certain prohibition in registration of design. What are the articles cannot be registered under design? If the design is not new or original, or it has been disclosed to the public before any kind of publication, or before any anywhere in India or in other country, because we are considering the global novelty in case of design registrations also. So you have to first apply and then you can disclose. But if you disclose first to the public and thereafter coming for registration, then your registration will not be done. And it should be significantly distinguishable from the known design. That means, you see, in our case of the patent, inventive step is there. Here also in design, significant distinguishable provisions are there, so that it can be distinguished by eye that it is different from the prior design, prior article, and it should not contain any scandalous or the obscene matter. Then only your design will be registered. So now the new or original design, not published, not India or any country, not contrary to public order or morality. You cannot go for registration of Ganesh. You cannot go for registration of Mahatma Gandhi. You cannot register for Netaji Subhash Chandra Bose or Swami Vivekananda. So it will go against the public order and morality. And also, person, the individual or legal entity claiming to be the proprietor, only when that design will not affect any security of India. Say, for example, submarine is using by our Indian Navy. You cannot go for registration of submarine also, because it is a defense product. But if we make a toy looking like a submarine, that can be registered under the class of toy, but not the big design which is generally using by Indian Navy for making the submarine or any fighting ship like that. So now I'm coming to the following articles are not registerable subject matters: calendar, greetings card, maps, labels, any principle or mode of construction, because it is going to the patent, and building structure, part of the article, and also the workshop alterations, mere change in size, small size or big size, flags, emblems, and also the computer icons cannot be registered under the Design Act. So you must keep in mind that who can apply for design. Any person can apply. Person also can include any company also, any individual, legal entity, micro industries, and the legal representative of the deceased person can apply for registration of design. Now the case is that you have the 4 office, and the Kolkata head office is now the design wing of the patent office. All the prosecutions, registration, examination is going to Kolkata office, but you can apply Delhi, Bombay, and Chennai office. Then Delhi, Bombay, Chennai office transfer your application to Kolkata office for the purpose of examination and registration of design. And now the jurisdictions also given that for registration of design you can apply, for extension of copyright, for cancellation and rectification of register, you can file the application in 4 offices, but the 4 office will not only Kolkata office will take the appropriate step, and the respective branch office will transfer the application to the Kolkata office for further actions. Now I am coming to the flowchart. The process is very simple. Within 6 months, you can get the registrations. After filing, a 6-digit number is allotted, and thereafter an examination report will be issued. But there is no publication like patent. In patent, there is an 18-month publication, but design will not be published before registrations. This is the only difference. And after issuing the examination report, within 6 months, you are to comply the requirements of the office. And if you can comply, then your certificate will be registered, your application will be registered, and your design will be notified in your patent office journal, and thereafter certificate will be issued to you. So 6 months time is the time by that time you can get the registration. And if your registration is not met, it will be refused by giving the hearing, and then you can appeal before the High Court. And also the High Court decision is binding upon the controller. If High Court is allowed your decision registration, then it will be registered and registered after notification, and that number will be entered into the register of design like patent also. So the particulars required for applications, this is very important. How to prepare, just like a patent, you are doing the complete specification. Drafting is very important. Here also form 1 should be filed. And also the 4th set of representation sheets you are to prepare in A4 size, and power of authority if you apply through lawyers. And if application originates from the foreign countries, then the priority document of the application also should be filed. And the A4 size durable paper, photograph or line drawing is required, diagrams, name of the views, statement of novelty, disclaimer, and the signature is required. Just I'm giving some example, then you can understand. And the representation sheet, you can also mention the novelty statement and the disclaimer statement. Novelty, there are 3 types of novelty. Your novelty may reside in shape and configuration of flower vase. Say for flower vase, you are going for registration, or in the article, there are certain portions you want to mark that this is my novel portion. Then you are the definition of the novelty definitions will be novelty resides in shape and configuration, particularly in the portion marked A and B of the flower vase as illustrated, or novelty resides in the, if it is not in shape and configuration, only surface pattern like carpet, then you have to mention that the novelty resides in surface pattern of the carpet as illustrated. Now, this is the representation sheet. You can find it is a teapot. If there is a mention of the novelty resides in the shape and configuration of teapot, and disclaimer statement, no mechanical or function is claimed, and no word, letter, mark is claimed, and signature of the applicant and agent. So this is the way you are to preparing the representation sheet. But this is a perspective view I am showing. The next slide is a biscuit. Here the biscuit also can be registered as a class of food. And here also you see they are marked the A, B portion, that my novelty is residing in A and B portion, not in the circular shape of configurations, because it is known to everybody. So they are marking and they are mention the novelty statement that the novelty resides in the ornamentation constructed by the holes A and B of the biscuit as illustrated. You see how the chair, in the case of the chair, you see the front view, perspective view, back view, top view, bottom view is given. And the novelty resides in the shape and configuration of the chair as illustrated, and disclaimer statement as given. If we look at the another view, the brush, toothbrush, lot of toothbrush is going for registration. You see the shape and configuration signifies something solid, where an idea has been incorporated into the article and mostly concerned with the 3-dimensional. There may be straight, there may be bent, there may be different types of ornamentations, and the patterns are also given in the handle portions also. So you see that different kind of representations can be prepared. This is also a kind of toothbrush where the pattern and ornamentation is given. The most of the big industry who are producing the toothbrush, they are going for registration of design and with the different patterns, shape, configurations to make the product looking good. So not the functional part they are claiming only the aesthetic part of the article. So the rights of the registered proprietor is that it has been given that whenever design is registration is given for 10 years and the exclusive right, and that it can be renewable, and for further 5 years, the total 15 years, you can have the registrations for the design from the date of filing of the applications. And also the copyright of the design, and it becomes the public property when after 15 years, when the 15 years period will be complete, then the design is go to the public domain like patent, and any public can use the design without falling into any infringement. That always coming into my mind that like patent, there is an opposition proceedings in the pre-grant opposition, post-grant oppositions. So here also the after registration of design, cancellation of design is also possible. If any public thinks that this design is a very old design, it is not new design, already it is in market. So by way of false suggestions, they have got the registrations. So they can come before the controller and can apply for cancellation of design, and according to the controller will take the hearing and cancel the design. I am not going into detail. So the controller's order also appealable before the High Court, and High Court shall decide the petition as referred to. And piracy, that is the infringement. In case of patent also, the infringement provisions is there. Similar provisions is also here, but it is called the piracy of registered design. If any piracy is made and the court thinks that yes, it is copied from the other products, then for every intervention, the contraventions court can give the award of 25,000 compensation, and total sum of recoverable debt is 50,000. So in the case of the infringement also, court can decide the matter and give the compensation to the registered proprietor for copying the product of the registered proprietor also. So the marking of the article is also very important, because there may be some innocent infringer. They may not know that it is already registered design, and many people cannot go for inspection of the register of design whether it is registered or not. So it is better for the registered proprietor to mark the number of the design number on the article, so that at the time of purchasing they can understand that this product is covered under registered design. So it is a unique selling point if you can put the registered design number on the article. But when the design will be lapsed or the term will be over, you should remove that design number. Otherwise, it will be a mistake on the part of the registered proprietor. So to avoid the infringement, from the innocent infringer also, the marking of the article is very important. So what to mark? That you have to mark the registration number, and to be so that it cannot be copied by others, but it should be discontinued when your design will be rejected or abandoned. And also, you should not mark your product with any false design number, because it will be a punishable offense in the eye of law also. So now the term of design already I have mentioned, 10 plus 5, 15 years. So lessons I am giving, because time is very short. The registration of design is must. Don't forget, first you apply, and then you go to the public for displaying your product, either through exhibition or any where design not to be disclosed in the public before registration, prior registration, and it should not be published not only in India but also in other countries, because in Design Act we are now considering the global novelty. So with this thing, just I want to conclude that good design is a good business. So if you can good design, you can create market leadership over your competitor, though your products may have the same functional value. Thank you everyone for my patience hearing.
Thank you so much, sir.
But time is very short. For that, I am going very fast.
Yes, sir. I think you have covered most of the part of the design. Such a nice presentation. Thank you, sir, for the joining. Dear participant, please turn on your camera so we can take one picture with Dr. Susil Kumar, sir. Sir, you can stop your presentation, so it will be full screen.
Yeah, yes.
Yeah. Thank you, sir. Please turn on your camera. So if anybody wants to give a feedback, so please unmute. Anybody from participant, please unmute yourself. So if you want to give a presentation, sorry, feedback. Yeah, we can see here Fenil Kantiwala. If you want to say something about today. I think your voice is not clear, so it's okay. So it's okay. We can tomorrow we have a session on trademark, copyright, GI, and traditional knowledge. So please stay tuned with us. Tomorrow will be a last day of summer camp on IPR for college and university student. Thank you, Dr. Susil Kumar sir, for the joining.
Thank you, madam.
So
Madam. Okay,
yes.
Thank you, madam.
Yes, sir. We'll end up.
Yeah, anyone have any question, then you please send the question and I will be ready to give the reply. Okay?
Yes, sir. We'll forward to you. So
Okay.
After collecting the
answer.
Yeah.
Thank you. Thank you very much. Okay.
Yes, sir. Thank you so much, sir. So we'll end up this meeting for today. Please stay tuned with us for tomorrow, day 3. That was the last day. We'll end up here.